In Malaysia, in 2014, something happened, and that is the famous MH370, the mystery of MH370. And 4 months later, it followed by another episode, that is the MH17. As what my Taiwanese friend tell me that, Mr. Chong, when there are 2 episodes, there will be the 3rd one coming along. Fair enough. Unfortunately, at the end of the year, in the December, there was another crash by AirAsia plane. In 2019, the arrival of this COVID-19 and has made our lives change totally. In fact, there's a lot of fears, there's a lot of worries, uncertainty, because sudden death happen so frequently among our family members, and our way of life have changed completely. Despite the fact that now there are a vaccine which is get us vaccinated, however, it seems that this episode of COVID-19 will not be away soon. It will be here for many years to come. That's what the experts say. So with this episode of COVID-19, coupled with the MH370 happened 7 years ago, life is actually very uncertain. Death can happen anytime, and the theory of elderly people go first does not apply anymore. The scary part is that nowadays we are not able to anticipate of its arrival. In fact, many of my friends told me that among their circles of friends, there are so many people just leave this world without saying a word to the family member due to COVID-19. So in 2007, as reported by Amanah Raya, there are about 40 billion of assets frozen by the government in view of the departure of, demise of family members. And in 2020, the figure ballooned to 70 billion, and that is confirmed by Amanah Raya. Why this happened? Under the Malaysian law, all assets under a person's name will be frozen when he passes on. For example, the houses, the share, the bank account, the car that the deceased owned, the factory lot, the safe deposit box. All these will be frozen under the law. And there is a misconception here that this asset will automatically go to their children or their family if they are no more around. In fact, this is not true. Generally, there will be a process to go through before able to transfer those assets to their loved one. Even though their loved one are entitled, they still need to go through this process. Let's start off with the classification of joint owned asset tonight. In fact, Malaysian assets that are under joint name fall under the tenancy in common. Meaning to say that if A and B joint own an asset, A has a 50% right to give away his asset to anybody he wants. Okay, to anybody he wants. So, but in the case of the neighboring, like Singapore or other European country or America, for joint asset, they classify as joint tenancy. The difference between joint tenancy and tenancy in common is joint tenancy, in the case of joint tenancy, in case one of the joint owner pass away, it will automatically give it to the surviving holders of the asset. That means the other joint owner. If there are more than one, then it will be equal share. If there's only one, then 100% will be given to the other joint owner. So that is why in a will, we need a valid will to apply a document called grant of probate if a person has a will. But however, if the person do not have a will, need to apply a document called letter of administration. Only then, with these two documents, we can unlock, or the family member can unlock the frozen asset. However, there are some exceptions on the asset that will get frozen. So basically, what is a will? Will actually is a declaration made by the testator in a form described by the law on matter which he wished to take effect upon her death. It is a document. It must be in a written form. It must be written in the form prescribed by the law on matter which should take effect upon death. He cannot just scribble on a piece of paper, say that if I am no more around, I wish to give my dog to my father, I give my money to my mom, because that type of document, as we normally say, is called death note, which has no legal implication, and the court will not grant the grant of probate based on this type of document. So basically in Malaysia, in fact, more than 90% of Malaysians do not have a will. And I hope you are not one of them, or if you are one of them, not to worry. After listening to this sharing, you will consider to write a will to protect your family and your asset. Tonight, we are going to share this very important slides for tonight's session. That is the legal administrative process in Malaysia. But however, there are some exceptions, So when a person dies, all his assets are frozen, whether it is a joint name or a sole name. So if there is a will written left by the deceased, this person died testate. That's the legal term. And what the executor name in the will need to apply a document called grant of probate. And with the grant of probate, the executor can take out all the assets, pay all the debts, and finally distribute the asset according to the will. In the case when there is no will, we call it die intestate. And in this situation, the family member need to appoint an administrator. And the administrator appointed by the family need to apply a document called letter of administration. And then once the letter of administration is extracted, the administrator appointed by the family will take out all the assets, settle all the debts, and distribute according to the Distribution Act 1958. However, when a person dies intestate, there are three scenarios that will happen. Number one, if the deceased left behind only with movable asset and the amount is less than 600,000, the family member or the administrator can go to Amanah Raya to apply the document called letter of administration. In the case where there is movable asset and the total asset of the deceased is less than 2 million, the administrator can go to small estate claim, or we call it district court, to apply this document called letter of administration. In the third case where a person has movable asset, totality more than 2 million, or it's a mixture of movable and immovable exceeding 2 million, then the administrator appointed by the family member need to go to High Court. And if the administrator go to High Court, there is an additional condition, which is that the administrator need to find two surety or guarantor, which will guarantee the integrity of the administrator. So with a situation like this, with the additional condition, it's quite difficult for big estate to get guarantor, people who are willing to be the guarantor for the deceased estate. That is why when there is no will, it takes years. And when there is a will, the grant of probate can be granted within 3 months currently, like what we see practicing now, and the whole process can be wrapped up when there is a will within a year for a small family or for a family with not complicated distribution. Okay, so in the case of no will, it could take months or years and to get the letter of administration extracted. And once the letter of administration is extracted, the administrator need to apply a document called distribution order. And with the distribution order, only then all the assets will be distributed according to the distribution order, which is a reflection of the Distribution Act 1958. Let's look at this effect of the Distribution Act 1958, amended in 1997. And a person passed away in Peninsular Malaysia or Sarawak, all the asset will be frozen. 25% will be given to the spouse, 50% will be given to the issue, and another 25% will go to the deceased parents. Okay, and challenges will arise when these parents, elderly parents, did not write a will or will away his asset that he acquired from the son, and it will end up most likely the sibling of the deceased will be the likely beneficiary. This is the effect of the Distribution Act 1958. Okay, and in the case of actual Distribution Act, this is what is shown on the screen now. Basically, it depends on who are living, surviving parents or living, surviving spouse or children. So there are a few, 1, 2, 3, 4, 5, 6 categories here. And generally, we are at the bottommost where we have spouse, we have parents, and issue. And the distribution will be quarter go to the spouse, quarter go to the parents, and half go to the children. And if the person who passed away do not get married, no spouse, no children, then the brother and sister will be the legal beneficiary under the law. However, if this brother and sister will wish to get the asset of the deceased, they still have to go through the same process that we mentioned just now. Okay, and if the family member do not proceed, at the end of the day, the deceased asset will go to the government. So for Sabah, this is a Distribution Act, and a slight difference here is the parents. Okay, in the case of Sabah, intestate succession ordinance, parents does not come in once you get married. This is a simple example of a classic Malaysian house, which is joint owned by 2 persons called Peter and Jane. And Malaysians like to have joint owned asset, but however, with the joint, what they call that, tenancy in common, it brings a lot of challenge to the family. For example, if Peter passed away, okay, then Peter's share, so 50% share will go to her parents, as well as the lovely wife, as well as the children. So you can see that the lovely wife will have to co-own the property together with the children as well as the in-laws. Okay, this will be the situation of who are the stakeholder of the house. So in a case when, what happens if the in-laws were to pass away without a will, and very likely they will go first or whatever, it will go to the other sibling, which is Peter's sibling, and this pretty young wife will have a lot of challenges because he is now going to co-own the property with all the brother-in-laws, which is the Peter's brother. What happened in the case where Peter and Jane both die together without a will? Then separately, Peter's asset will be distributing according to the Distribution Act because there is no will, and at the same time, Jane's asset will also distribute according to the Distribution Act because she doesn't have a will. And both parents and in-laws will come into picture to own partial of the property. And what happened if the parents that pass away, that will resulting in more in-laws, brother-in-law or sister-in-law to come in to co-own the property, and what will happen to their children. This is a result of a Distribution Act pertaining to immovable property. So conclusion, a will is needed to protect our family member, our loved one, to make the transfer of asset like